Stand in court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Okay, we are here this morning in the matter of Victor R. Marshall, an attorney suspended from the practice of law in the courts of the state of New Mexico. The Supreme Court cause number 37698. May I have entry of appearances, please?
Good morning, Your Honors. Jamie Atkinson, Disciplinary Board of the
Good morning.
Good morning, Your Honor.
Thank you. As I understand it, Ms. Agnew, you've got 10 minutes for opening and 10 for rebuttal. And Mr. Marshall, you had 20 minutes as set forth in our rules. Just to bring everyone up to speed here, we're here pursuant to the order to show cause filed on August 16, 2022. And I'll read that order to show cause. Whereas this matter came on for consideration by the court upon petitioner's third verified motion for order to show cause, respondent's additional affidavit filed as a response thereto, and the court having considered the foregoing and being sufficiently advised, Chief Justice C. Shannon Bacon, Justice Michael E. Hill, Justice David K. Thompson, Justice Julia J. Vargas, and Justice Brianna H. Zamora concurring. Now, therefore, you, Victor R. Marshall, are ordered to show cause, if any you have, why you should not be held in contempt of court and be subject to additional sanctions up to and including disbarment from the practice of law for failing to fully comply with this court's May 26, 2022 contempt order requiring you to do the following. 1, comply with Rule 17-212 NMRA by 5:00 p.m. on June 2, 2022. 2, pay the sum of $2,000 to the State Bar Client Protection Fund and notify this court in writing when such payment is made. It is further here ordered that a hearing on this order to show cause will be held at a date and time to be determined by this court, and that notice of the hearing will be provided to the parties. And it is further ordered that you, Victor R. Marshall, are ordered to appear before this court at the date and time set by this court for the aforementioned hearing to show cause for violation of this court's order dated May 26, 2022. In addition, there is an order entered on June 30, 2023. Without reading the preambles, it reads, now therefore it is ordered prior to presenting any evidence or argument to the court at the show cause hearing on July 13, 2023, respondent shall be placed under oath, and it is further ordered that respondent shall appear in person for the show cause hearing. With that background in mind, Ms. Gagnon, you may proceed.
May it please the court. Justices, Victor Marshall is in open defiance and flagrant disregard of this court's authority. That disregard and that defiance cannot be allowed to stand. In Ray Salazar at 219 NMSC 10, which the court is aware, having cited it previously in its orders in this case, the court stated rules matter. An attorney must conform his or her conduct to requirements of the rules and orders of the court. In that case, Mr. Salazar was up before the court on a contempt motion for his failure to abide by Rule 17-212. The court gave him opportunity to come into compliance with the court's orders and the rule, and initially he did not, but finally he did. And it was only because of that that the court did not disbar Daniel Salazar. In this case, this court has given Mr. Marshall ample opportunity to come into compliance with Rule 17-212, ample opportunity to obey this court's authority and obey this court's order. And Mr. Marshall will today, again, defy this court's authority because he has indicated in an affidavit filed this morning that he will not subject himself to sworn testimony. What is so baffling about his contemptuous behavior is that it would be so easy to come to compliance. It would be so easy to comply with Rule 17-212. It would be so easy to comply with this court's order. It would be so easy to swear as an unlicensed attorney that he would tell the truth before this court, but he refuses to do all of those things. He holds himself above this court's authority. This court needs to send a strong message that such incredible contemptuous behavior will not be tolerated. His affidavit, his additional affidavit that he filed on July 7th, 2022, does not address the allegations of the motion for order to show cause. Instead, he attacks Rule 17-212 and attacks these proceedings. There is simply no justification for his attacks. He has, in effect, admitted that he has violated the rule because he does not contest, he does not present any evidence that he has complied with the rule. He does not present any evidence that he has complied with this order. Instead, he continues to attack this court's authority. In State Ex Rel Apodaca versus Art Chapel of Memories of New Mexico at 74 New Mexico 201 at page 769, that the court said, in imposing punishment for criminal contempt, there are three factors that must be considered. The seriousness of the consequences of the contumacious behavior. The seriousness of this behavior is extreme because he has defined this court's authority, and the legal system and the professional system cannot function without respect for this court's authority. For the same reason, the public interest in enforcing a termination of defendant's defiance. Same logic applies, and the importance of deterring future conduct. Now, as to whether direct or indirect, there are both in this case. The court has personal knowledge of Mr. Marshall's defiance in his additional affidavit and his filing this morning of the affidavit.
Excuse me.
Simply is no choice.
Did I hear you right?
Disbarred, yes. Now, if the court has any questions, that is my argument, but if the court has any questions, I'm happy to answer them.
Ms. Gagny, can you clarify, there have been no additional notices sent pursuant to 17-212 since we were here last May, is that correct?
That is correct.
Thank you.
He has done nothing. And just to summarize, as the court knows, he did not provide the notices which he say constitute compliance. He did not file them with the court. We believe that he did refer his clients to new attorneys in defiance of the rule.
Thank you.
Question. Thank you, Ms. Gagny. Mr. Marshall, court will now hear from you. Let me first ask, are you sticking by your affidavit you filed that you will not be sworn this morning?
Your Honor, let me address that. This affidavit.
By the way, you have 20 minutes beginning now, so.
Just preliminary matter. We tried to file this yesterday and weren't able to. We had some Tyler Tech problems. We got it filed this morning. I'd also note that you should strike the word Esquire next to my name. That's an artifact from an earlier pleading. It is correct that I am currently suspended. Let me just say that on June 20th, the court entered an order which reflected an earlier order saying that I could not present anything. Argument, I could not speak at all unless under oath. So to comply with that order, I have placed myself under oath and I have filed this affidavit. And that is what I have to say. And that is complying with the court's order.
So you're not willing to be sworn today, at this time, before this court, at this proceeding?
The answer is in my affidavit. And if I could just read the salient.
Go ahead.
First, I've been sworn. I take that oath very seriously. 1, the court has asked if I am willing to testify under oath concerning this controversy. 2, yes, I am willing and eager to testify under oath according to law. The law concerning sworn testimony can be found in the Constitution of the United States, the Constitution of New Mexico, the rules of civil procedure, the rules of evidence, the statutes, and numerous court cases. These laws exist to uncover the truth and to protect witnesses and all parties. Period. 3, I am more than willing to testify in any forum which takes testimony in accordance with the law. One such forum is the United States District Court for New Mexico. In the case of Marshall versus Bacon, number 1:23-CV-00494. Excuse me if I don't read it right. I have number dyslexia. GBWJFR. District courts are able to take testimony, unlike appellate courts. So I'm offering to testify under oath at a deposition at the earliest feasible time during discovery in that case. Further affiant saith none. Under penalty of perjury, under the laws of the state of New Mexico, I affirm that this statement is true and correct. That is my statement, and that is all that I am permitted to do under the constraints and the previous orders of the court.
Mr. Marshall, we will hear you today under the circumstances you've described, and we will get whatever you have to say today, the weight that it is that we deem appropriate under the circumstances. So you're free to proceed to answer to the motion to order to show cause. You have 16 minutes, almost 17 minutes. So you're free to proceed.
If I were to proceed under the orders of the court, I would be subject to direct contempt, summary direct
I am
contempt.
telling you, you're free to proceed. If you have any consternation about proceeding and being held in contempt for proceeding today, I'm telling you, you have nothing to fear. So you may proceed or you may not proceed. It's up to you.
My position is stated here, and it's stated more fully in federal court. Thank you.
Okay. So Ms. Gagnon, you have 10 minutes for rebuttal.
Justices, I think I've said it all.
Okay, thank
He has
you.
not rebutted any of the allegations.
Thank you. So given the unusual posture of the case and the numerous issues that are raised by the order to show cause and the various orders that have been entered in this case, the court would ordinarily see if we could come to a decision today and announce our decision. But given the factors I've described, we will take the case under advisement and we will issue an order forthwith. Any questions? Mr. Marshall. Okay, thank you. We will be in recess.
And the court, please.